Judge Roper let the slack out on his leash so he could just do and have whatever he wanted.
He doesn't want to show his face or share his name, but this young father says Doug Nelson was the guardian ad litem assigned to his case, one that didn't get a ruling in his favor.
He pretty much did whatever he wanted to do with no regard for me and my family.
Father says the ruling is surprising because of his ex-wife's trouble with the law. Nelson's August 12, 2013 guardian ad litem report notes the wife's 2012 arrest for manufacturing marijuana and child neglect, charges backed up by past court records. Nelson also noted the mother's charges were dismissed and she was working to get them expunged, and according to court officials, the charges can no longer be found on the books. Nelson recommended the mom get visitation rights, but Superior Court Judge David Roper took it one step further. He said after considering several factors, he said the child had a better bond with the mom, and in a final ruling on August 12, 2013, gave her primary physical custody. We did call and text listed phone numbers for the mother, but have yet to hear back. The father says he decided to step forward after seeing our original story where women accused Nelson of being inappropriate with them. He says he saw some similarities in his own case because of what he says one witness was sent.
Similar text messages that were as inappropriate or even more inappropriate in some cases.
In documents the father gave us, local attorney Andy Tisdale emailed screenshots of text messages to Judge Roper on August 22, 2013. Nelson allegedly sent the messages to the child's teacher, who was a witness on the case. We reached out to Tisdale, who did not represent the litigants or witnesses in this case, and he confirmed the authenticity of the email but denies releasing it to other parties. In the messages, Nelson tells the teacher she's the most beautiful he's ever met and that he came to the school to see her, waiting for an hour in the office after music class. She thanks him for the compliments and for being honest, but then tells him they must keep their communication professional. Multiple attempts to contact the teacher were unanswered, but in a sworn statement on August 12, 2013, the teacher confirmed she did receive what she called inappropriate remarks to her cell phone, and they were reported to the school principal. However, Judge Roper says he did not allow the statement to be admitted as evidence in the case, and he says it is his policy not to discuss the specifics beyond actions in active, past, or upcoming cases. Multiple calls, emails, and messages for the school principal were also unanswered. We asked Judge Roper about the email. He confirmed he did receive it, but says since he had already ruled on the case and since Nelson had resigned as a guardian altogether on August 13th, the point was moot. When we pressed him about not reporting the text messages to another agency like the police, he said while the messages were inappropriate, he didn't feel the crime had been committed and that sexual harassment is not a crime in Georgia. Father in this case says he felt hopeless about the situation.
I tried every legal route I could think of to get help, and no doors opened up for me. No one was willing to help.